How does Congress legally get away with all their unconstitutional activity? The Federal Reserve? The Patriot Act? The Healthcare Bill? Cap and trade? Federal income taxes? What follows is fact, not fiction. It is not conspiracy theory or patriot myth. It is all 100% documented. The truth is that the United States you believe to be a country is nothing more than a private, for-profit business operated by an unlawful Congress for the benefit of a handful of international bankers and controlled by the Vatican. America is a corporate slave plantation. On February 21 in 1871, the nobility of Congress officially created a private, for-profit municipal corporation that they could legally control under Article 1, Section 8, Clause 17 of the Organic Constitution, and then proceeded to give it all the power and authority not inconsistent with the Constitution and laws of the United States. See Congressional Record, Organic Act of 1871. What did Congress name their new private business enterprise? They named their new company the United States. Let me be very clear about this important issue by restating it. In 1871, Congress created a private company called the United States over which they had complete legal control, and gave it powers not inconsistent with the Constitution and laws of the United States. The District of Columbia, aka the State of New Columbia, is unlike any other municipal corporation on the planet. For within the 10 miles square known as the District of Columbia is a privately held corporation legally named the United States with all the power of the Organic Constitution for the United States of America. Any participation within this private, for-profit commercial entity is presumed to be a legally binding contract based on our consent, to be adjudicated by them in their private commercial courts. Amazingly, most Americans still believe a legitimate government and system of law exists and they live in a free society. Sadly, nothing can be farther from the truth. Truth be told, the American people are nothing more than feudal serfs, slaves, within a system of public policy that captures all corporate U.S. citizen persons' assets through a deceptive, but voluntary 14th Amendment U.S. citizenship. The fact is, every single courtroom currently operating within one of their state of franchises is a non-Article 3 legislative tribunal acting as collection agent for Congress's private, for-profit commercial business and administrator of FDR's corporate U.S. bankruptcy of 1933. Every Department of Justice court across America is a private commercial law merchant court operating only for the generation of corporate profits. To be clear, there is never a lawful non-fictional non-commercial cause of action in their private court system. Never should a sane man or woman walk into one of their private, for-profit commercial courtrooms and expect the Constitution to magically appear or the common law to be recognized, upheld, or enforced. The sooner we all accept that we have no law, and we have no government, the sooner we can take back what has been fraudulently stolen by the Crown-controlled thieves in Washington, D.C. its private central banking system, the Federal Reserve. Only then can we start rebuilding what is left of America. Only then will we have a monetary system based on real value. Only then will we, the American people, truly regain our freedom, liberty, and God-given unalienable rights. There has been no true freedom or lawful government since the creation of the United States Constitution. We have been under military rule since dictator Abraham Lincoln issued Executive Order No. 1, April 15, 1861. No American claiming U.S. citizenship has a vote or any representation in their private Congress. We must educate ourselves on the U.S. asset 14th Amendment citizenship that holds us in bondage. The Declaration of Independent States, governments are instituted by the consent of the governed. Now is the time to withdraw our consent.
The American Illusion. Background and framework: the Roman civil law republican government founded by the original Constitution, 1787, is claimed no longer operational. Instead, what is called the Government of the United States is a bankrupt private corporation, owned, underwritten, and functioning in commerce as a front for the international bankers and the powers that be with which said bankers are allied. The entire institution, i.e., US Inc., is private, not free, enterprise administering the ongoing business and political ends of the actual owners. In this current scenario, every action of US Inc. is a commercial transaction by and between fictitious entities, all transpiring for the purpose of furthering the economic and political objectives of the alleged creditors. This situation arose from the borrowing by USA from European central banks and owing the unpaid indebtedness to the Crown from the original joint venture agreement between the colonies, which are corporations of the Crown, and the Crown per se. It appears as though USA has been bankrupt from inception, i.e., from 1788, and the Constitution was drafted to reconstitute the unpaid debt and structure an organization for functioning in bankruptcy. The Civil War was staged and financed by the bankers and the Crown to conquer the nation by engaging in the timeless strategy of divide and conquer. Pitting North against South resulted in the dissolution of the de jure federal government of the Organic Constitution. The states were drawn into the central government, as were, progressively, the people directly, with the whole conglomerate operating through the new federal government in the emergency war powers of 12 Stat. 319, 1861, under the law of necessity. Thus, the government functions under mere color appearance only of government, with the president as acting dictator on behalf of the bankers under the president's capacity as commander-in-chief of the military. I.e., when the 7 southern states walked out of Congress on March 27, 1861, Congress, and, indeed, the entire de jure government of USA under the original Constitution, dissolved based on absence of a congressional quorum to adjourn and reconvene. The result is that the actual winner of the Civil War was neither the North nor the South, but the bankers who owned the new federal government that defeated both North and South and absorbed and subserved the states into itself. In accordance, inter alia, with the Limited Liability Act of 1851, the Emergency War Powers, 12 Stat. 319, the Civil Rights Act of 1866, and the constitutional provision allowing Congress authority to pass any law Congress wishes within the 10-mile square territory of Washington, D.C., Article 1, Section 8, Clause 17, the 14th Amendment was proclaimed ratified in 1868. Within that framework, on February 21, 1871, Congress passed the District of Columbia Organic Act, 41st Congress, Session 3, Chapter 62, page 419, 16 Stat. 419, an act to provide a government for the District of Columbia, which act was revised in 1874 and reorganized June 8, 1878, 20 Stat. 102, Chap. 180, 45th Congress, 2nd Session, an act providing a permanent form of government for the District of Columbia. This government is a private corporation now known and copyrighted by such names as the United States Government, United States, US, USA, etc., all referenced herein as US Inc. It is important to understand that US Inc. is not a country, but a corporation, and indeed a bankrupt corporation operating under color of government as the front and device for administering the conquest in law and commerce of the United States of America. The 14th Amendment and US Inc. are all private international law in the Admiralty Maritime Law Merchant of Roman Civil Law. The 14th Amendment states, all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. This amendment allows US Inc. to have complete jurisdiction over citizens, i.e., corporate subsets of US Inc., which the de jure federal government did not and could not possess. The 14th Amendment also states, Section 4, the validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, per 12 Stat. 319, shall not be questioned. The 14th Amendment established the framework for complete conquest and absorption of the country, rendering the people permanent debtors, indentured servants in involuntary servitude, peonage, and also enemies of the government as a result. In accordance with 12 State 319, any aspect of US Inc. may summarily confiscate property in rem without necessity for judicial process whenever any citizen asserts a challenge to the laws of the United States, i.e., US Inc. Remnants of the de jure government remained after the 14th Amendment, however, based on such things as the continuing circulation of gold and silver coin, the money of sovereigns, and the fact that senators were still elected to the Senate by electors of the states rather than by direct, popular vote. Senators became elected by direct vote of the people with the passage of the 17th Amendment. The Civil War had forced each sovereign state to pledge its assets as collateral and become surety and a cosigner for the defaulted federal government's debt to the bankers. This procedure was repeated in the 1933 bankruptcy, at which time gold and silver coin substance were outlawed as money for citizens of the United States. Fictions. Inability to use gold and silver as money solidified the bankruptcy of US Inc. and foreclosed every such citizen from accessing real money for use in payment of debts, thereby denying access to sovereignty. US Inc. is completely devoid of rights, substance, standing in law, and sovereign character, as is every citizen of the United States. The creation and nature of the strawman. Because additional pledging of assets was required to enable the now bankrupt corporation to continue to operate when civilly dead, the governors of all the states met to discuss the emergency declared by Franklin D. Roosevelt, i.e., the bankruptcy, and how to reorganize US Inc. to continue functioning when bankrupt by means of insurance underwriting by the creditors. The governors of the states made a pledge to US Inc. to underwrite the bankruptcy through a grand scheme of limited liability insurance. The people, through their certificates of live birth, aka newborn identification, were registered in the office of the county recorder by registered agents of the government such as the registered doctor and registered nurse, and were thereby established as property of the state. Remember, register derives from regius, meaning king, whereby everything registered is there to record and keep track of the king's property. The newborn identification is identified with, and attaches to, the flesh and blood being by taking a drop of blood and the print, usually footprint, of the baby and applying them to the newborn identification. Once that certificate is registered, it is recorded as a certificate of title, as it were, to the real being. Since the point is to be able to enslave the child and render him a surety for the debt of the bankrupt U.S. Inc., it makes no difference who or what the baby is. Everyone becomes classified as fungible goods, like interchangeable bales of cotton. The parents did not understand what was happening, so the process was thereby fraud based on deceit and non-disclosure. Obviously, with full disclosure of the terms and conditions involved in the alleged contract, no one would agree to go along with it. The agents of the government perpetrate a fraudulent transfer by registering the name, blood, and footprint of beings that is birthed by the living woman and not the corporate state, which can generate only more legal fictions, not real beings. This process amounts to theft of the real being by filing a piece of paper. The state did not create the name from which the all-caps strawman was derived, only colored the name into a form they could use. The name in upper and lower case letters pertains to the real being, while the all-caps strawman is a legal fiction used as credit against which to borrow at the expense of the life force of the living being to which the name and registered newborn identification allegedly relates. When the governors of the states, at the Conference of Governors of March 6, 1933, pledged as state-registered assets the newborn identifications of those born in the state to the federal bankruptcy, the People's Energy was established as the collateral for backing the whole operation, the entire national debt. Since the states, being fictitious, commercial entities with no capacity to recognize real beings, could not pledge private, living people or their property, a bridge was needed between the living people and the bankruptcy of the federal U.S. Inc. To accomplish this result, the Department of Commerce in Washington, D.C., in order to function as a shill to operate out front publicly in place of the people, created the strawman. The scheme had to be so clever that the people would agree to operate as surety for the debts, charges, and obligations of the strawman without knowing what was happening to them, who did it, what they were agreeing to, or how the whole process worked. The birth certificate with the all-caps name created by the U.S. Department of Commerce is a certificate of equity interest, akin to a pink slip, pertaining to a vehicle, and possibly a bill of lading, a document of bailment, which ships the cargo, new and original birth certificate, into the special maritime jurisdiction of the creditors to operate as collateral to back the bankruptcy reorganization of U.S. Inc. via the governor's pledge. The all-caps strawman is thereby birthed, like a vessel, into the private, international law special maritime jurisdiction of the bankers, al., as a citizen of the United States born, birthed, or naturalized in the United States and subject to the jurisdiction thereof. By this scheme the living people assumed the role of guarantor, accommodation party, and surety for the legal fiction that functions for the benefit and enrichment of the creditors. In this scenario it is the strawman, not the living being, that operates throughout the entirety of today's law and commerce. One need only look at the Social Security card, school records, passports, driver's licenses, credit cards, utility bills, etc., all of which are always in all capital letters, just as are gravestones of dead people all over the world and the parties to a dispute on the caption of a court brief, to see the ubiquitous use of the strawman in today's commercial and legal world. A surety is defined as the one who is responsible to pay. The real man is the surety and liable by contract to pay for the debts and obligations of the strawman, even though the real man is not, nor does he own, nor does he receive title to, anything purchased or accomplished by use of the strawman. The strawman is owned by U.S. Inc. and the banks that purchase bonds issued by the Treasury against the strawman as credit. As stated, U.S. Inc. is bankrupt, and has been since 1933. U.S. Inc. has no gold or silver to pay any debts and is civilly dead. Having neither possession, nor right of possession, nor legal capacity to use gold and silver, i.e., lawful money, the only asset left to finance the continued operation of the bankrupt U.S. Inc., i.e., the government, was the people, who were hypothecated as the credit collateral to finance the bankruptcy. U.S. Inc. uses the substance and labor of the people to finance its entire operation, reorganization and insurance underwriting. The scenario is extremely sophisticated, resulting in the operation of a vast and pervasive administration of legalized peonage, slavery, permanent indentured servitude, and collectivism, communism, wherein the people have forfeited all standing in law and are dead to rights. The powers that be borrow against your life, rights, and labor to finance their administration of the system they use to exploit, plunder, and dominate you, all under the presumption that they are acting as your agents to fulfill your own requests. In this scheme, one is punished when one fails to pay or obey. The sequence of steps involved in creating the existing system, in accordance with the best research to date resulting from the efforts of many devoted people, is as follows in the United States. 1. A living, flesh and blood baby is born from its mother's womb. 2. The legal, commercial system, existing and functioning entirely in the abstract realm of words, contracts, legal persons, corporate entities, laws, symbols, ideas, commerce, private international law, etc., which constitutes the matrix, cannot see, recognize, or deal directly with the real world, including real people. The system itself is imaginary, while the real world is genuine and substantive. Consequently, the system deals only with documents and matters in the abstract realm that form, by presumption, ratified implied contract attached to the real world by operation of law and the tacit consent of the people. 3. Just after birth, the involved doctors and hospitals have the mother sign a birth certificate, i.e., a certificate of live birth, without telling the mother, and undoubtedly without themselves knowing the truth, that by so doing she and the doctor are criminally informing on her newborn baby as an enemy of the state in accordance with the war powers and turning the baby over to the bankers as chattel property and slave, pledging the baby's life energy and labor in perpetuity as the collateral for borrowing into existence all currency. Debt paper that passes as money today. 4. The original birth certificate, a certificate of live birth, constitutes, as it were, a certificate of title to the real being, and is in essence the equivalent of a manufacturer's statement or certificate of origin, i.e., MSO or MCO, which is created upon manufacturing an automobile and constitutes title to the vehicle. 5. Just as in the case of a car, anything being registered in the legal system is established on the record as property of the king. The key here is registered, a word deriving from regis, meaning king, whereby everything registered is recorded as the king's property. 6. The sequence of steps concerning the birth certificate appears to be as follows. A. After registration of the certificate of live birth in the office of the county recorder makes a certified, true copy or microfilm, retains it, and sends the original to the Department of Commerce in the state. B. As in the case of the county recorder, the State Department of Commerce makes a certified, true copy or microfilm, retains it, and sends the original to the Department of Commerce of the federal government in Washington, D.C. C. The Department of Commerce in Washington then makes a certified, true copy and, in addition, creates a new document, constituting a certificate of equity interest, which is labeled birth certificate. This birth certificate, however, has the child's name in all capital letters, unlike the original birth certificate filed in the county recorder on which the name was in upper and lower case letters. D. The Department of Commerce in Washington, D.C. then forwards the originals of both documents to the record repository in such locations as The Hague, for holding on behalf of the international banks, e.g., the World Bank, the Bank of International Settlement, IMF, AL. There the documents remain on deposit as the collateral asset for hypothecating into existence the credit that finances the underwriting of the world's bankrupt governments. 7. By this means, the people become the utility for the transmission of energy from reality into the fictitious, colorable realm of international commerce. The private, international law that governs the legal, commercial system today is the Uniform Commercial Code, which is established as the law of the land in the United States in Public Laws 88 to 243 and 88 to 244. The UCC is private, not public, law, and is copyrighted by Unidroit, an Italian corporation out of the Vatican. Now the people, via their all-caps names, are classified as human resources, and goods, under the Uniform Commercial Code, see Section 2 to 105(1) and 9 to 105(1), in which animals, i.e. humans and their unborn offspring, become goods, saleable in commerce. The Department of Treasury issues bonds on the birth certificates, which are sold through securities exchanges and purchased by extending credit on the bank's books by the Federal Reserve Bank, which uses the bonds as reserves for creating credit in the fractional reserve system. The people's labor becomes the collateral for issuing Federal Reserve notes or some other form of debt obligation, see 18 U.S.C. Section 411. The bonds are held in trust for the purchaser, now the secured party and holder in due course, at the Resolution Trust Company at 55 Water Street, in New York City, about 2 blocks down the street from the Federal Reserve. It is a high-rise office building with a sign that reads, "The Tower of Power." After the New Deal, the all-caps name, hereinafter, strawman, is what the system deals with, since it cannot interface directly with real beings. The real being, however, is presumed to have ratified the deal, agreed to the pledge, by the 3 means for signifying ratification of implied contracts. Thereafter, the system functions on the basis of possessing complete authority to do anything it wishes with the strawman, which is the system's own creation and property and does not belong to the living being to whom the strawman purportedly pertains. This scheme of legal, commercial peonage and slavery is outside the Constitution, which does not apply in any matters concerning the resulting process. The system functions in the realm of private contract, private international law, in international commerce, i.e., the private international law of the private, colorable law merchant, not within the direct purview of the Constitution, which merely sanctifies the operational right to contract. Thereafter, every time the real being signs his name on any legal, commercial document, he is creating more debt currency into existence, signing as the surety, or accommodation party, per the Uniform Commercial Code section 3 to 415. He is also placing title to whatever property is involved in the hands of the bondholder. In this scenario, the name, i.e., strawman, is credit and is a constructive trust created by operation of law, i.e., fiat, holding all the real assets, i.e., sweat equity, created by the labor of the real being. The right to the use has been separated from the title. The strawman holds the title and belongs to the bondholder, not the real being. The flesh and blood man or woman has only naked possession with a limited right to use the thing, such as one's body, possessions, or land. Such illusion of ownership and right is essential to maintain the sting on an ongoing basis, keep the people from completely rebelling if the status as slaves was self-evident, and fostering more enthusiasm to work and produce by thinking that they are doing so for their own benefit rather than for the enrichment and power of their owners, masters, rulers. When the strawman violates some rule or statute, such as is presumed whenever the strawman receives a traffic ticket, the flesh and blood being must appear at an arraignment and admit that he is the surety and accommodation party for the strawman, and thereby agree to provide the energy necessary for providing whatever fine or penalty is deemed due and payable. The real being has reconfirmed the contract of implied unification of the real being with the strawman by saying, here, when the strawman's name is called in the idem sonans, i.e., same sound, tribunal. This is why it is essential for the operation of the system that people voluntarily give their names to the court. The defendant in the action is the strawman, not the real being. The real being confirms that he is, or may legally be treated the same as, the defendant. Through this process one has entered through a door over which is inscribed, "Abandon hope all ye who enter here." It is now clear that the strawman is 1. A nom de guerre, meaning a name of war, whereby the strawman is regarded as being in a state of insurrection or rebellion, per Section 4 of the 14th Amendment, 12 Stat. 319, and the Trading with the Enemy Act, 2. A straminius homo, or strawman, the legal and commercial consequences, aspects of which are that it is a permanent debtor in legal incapacity, a dead estate, 3. An artificial entity owned by the secured party who bought into the bond placed on the market by the U.S. Treasury. It is important to remember that the strawman is not the property of the real being. The living man or woman is merely the surety, succor, providing the labor, life energy, and sweat equity for the fiction owned by US Inc. and the bondholder. The strawman is the front that enables the secured party to act in legal, commercial dealings without revealing his identity, and to deceive the real being, who signs in all matters as a surety and accommodation party, into thinking that the real being is doing something for himself rather than his owners, masters. Everything the real being signs on behalf of the strawman places title to whatever property is involved into the hands of the United States and the bond owner, i.e., the secured party over the strawman. Do the American people have a claim on their all-caps strawman? The short answer is, yes, but only after the American people assert that claim properly. Otherwise, the presumption remains that US Inc. and the owners of the bondholders own the strawman. The foundation of our claim is that they did not originate the strawman, but merely altered the original name by changing the upper and lower case name into a same-sounding name spelled in all capital letters without full disclosure. That all-caps name is used to finance the system of power and self-enrichment of US Inc. and its owners at the expense of the enslavement of the people. They do not possess any authority to use the name based on the unlawful object of intent to perpetrate the scheme to reduce the people to slavery and peonage by engaging in fraudulent concealment and a mountain of other crimes. In addition, it is the living being to whom the name refers that provides the labor, substance, and life force that gives value to the strawman, and thereby authorizes the real being to claim superior title to it. Those who expropriate the output of others for their own unjust enrichment, subjugate the populace, and bring about the ruin of those from whom they steal the rights, life force, labor, and wealth, have no legitimate grounds to assert a claim of superior title, either in law, equity, or commerce. There is a sequence of steps that must be done to become free of the bondage system that now enslaves mankind and regain lost freedom and independence. The system has not, to say the least, been forthcoming in educating the people concerning the true legal and commercial situation to which virtually everyone in the world is now subject. A mother having given birth to her baby is not informed that by allowing her child's birth certificate to be registered she is, for instance, 1. Informing on the baby criminally and declaring her newborn infant to be an enemy of the state with no rights, 2. Consigning the child to permanent slavery, peonage, and indentured servitude, 3. Declaring her baby to be fungible goods and the chattel property of the bankers and world powers. If full disclosure, good faith, and genuine meeting of the minds prevailed, as is required for any purported contract to be an actual, bona fide contract enforceable at law, and the people knew the truth, the banks and governments of the world would be out of business.
Who says we need a license? A license is a sin. A license is a permit to sin. A conscientious objector is not what you thought it to be. Oh, in the combat sense of the word it may be, but it hits a lot closer to home than that. Are you licensed? Yeah, do you have a license? If so, you're condemned by your creator. That statement was thrown in to get you to discover a well-hidden truth. A crafty bargainer has duped you. Read, at least to the end of definition, and tell me I'm wrong. The objection of a conscientious objector must be founded on deeply held moral, ethical, and religious convictions about right or wrong. Man, one of Adam's progeny, cannot be licensed. One of the biggest devices of the confiscation and asset forfeiture plague and the state stampede of licensing is the use of personification to confiscate property. Personification is the idea that things or objects possess the free will and capacity to commit crimes. It is an idea deeply rooted in the practice of witchcraft, the occult, and devil worship. Objects are supposed to get that kind of power from the devil, or a curse. A license issued by a fiction, corporation, government entity, etc. is a permit rendered to another fictional legal entity to do what would be otherwise against natural law. The license is a permit for you to lie to your senses, allow a fiction to rule over truth. Definitions follow. A license to lie to the senses equals license, a permit to lie to the senses. Jude chapter 1 verse 4 For there are certain men who crept in secretly, even they who were of old written of beforehand to this condemnation, ungodly men, turning the grace of our God into lasciviousness, and denying our only Master, God, and Lord, Jesus Christ. Strong's Concordance, lasciviousness, wantonness, word number 766 unbridled lust, excess, licentiousness, lasciviousness, wantonness, outrageousness, shamelessness, insolence. Lasciviousness and wantonness mean licentiousness. Heritage Dictionary, Lee Cent Ag. 1. Lacking moral discipline or ignoring legal restraint. 2. Having no regard for accepted rules or standards. Latin licenti 1/2 sus, from licentia, freedom, license. See license. License n. 1. Official or legal permission to do or own a specified thing. See synonyms at permission. B. Proof of permission granted, usually in the form of a document, card, plate, or tag, a driver's license. 2. Deviation from normal rules, practices, or methods in order to achieve a certain end or effect, poetic license. 3. Latitude of action, especially in behavior or speech. See synonyms at freedom. 4. Lack of due restraint, excessive freedom, when liberty becomes license, dictatorship is near. Will Durant, B. Heedlessness for the precepts of proper behavior, licentiousness. Remember, the legal definition of license is a permit to do something that would otherwise be illegal. Remember also, that legalese only gives enough information to place the inquirer off balance and believe the intended meaning of the person defining the word, quite often to the believer's injury. World English Bible 2 Peter chapter 2 verse 18 For, uttering great swelling words of emptiness, they entice in the lusts of the flesh, by licentiousness, those who are indeed escaping from those who live in error. Darby Bible Mark chapter 7 verse 22 Thefts, covetousness, wickedness, deceit, licentiousness, a wicked eye, injurious language, haughtiness, folly. 2 Corinthians chapter 12 verse 21 Lest my God should humble me as to you when I come again, and that I shall grieve over many of those who have sinned before, and have not repented as to the uncleanness and fornication and licentiousness which they have practiced. Galatians chapter 5 verse 19 Now the works of the flesh are manifest, which are fornication, uncleanness, licentiousness. KJV Psalms 5-6 Thou shalt destroy them that speak leasing, the Lord will abhor the bloody and deceitful man. Leasing, strong number, 3577 A lie, untruth, falsehood, deceptive thing. Leasing is just another word for licensing. Licensing, or licentiousness, is the factor that has placed us back into bondage. Deuteronomy chapter 28 verse 68 And the Lord shall bring you into Egypt again with ships, by the way whereof I spoke unto you, you shall see it no more again, and there you shall be sold unto your enemies for bondmen and bondwomen, and no man shall buy you. What does the power elite call United States? New Egypt. And it is a fiction, you shall see it no more again. And you have been brought into slavery by way of artificial vessels, ships, called a straw man. And no man bought us as slaves, we sold ourselves into bondage to our enemies who never paid a dime for our credit or us. Isaiah chapter 52 verse 3, Ye have sold yourselves for naught, and ye shall be redeemed without money. End of definitions. Now, move into truth like you've never known it and learn how to escape from Egypt. Just remember, a license is a permit to lie. Colossians chapter 2 verse 20 NIV Since you died with Christ to the elemental spiritual forces of this world, why, as though you still belong to the world, do you submit to its rules? Bottom line, a license, any license, all licenses place us in a subordinate slave position. Licenses apply only to the fiction, the unreal, the not alive. To have a license is truly against my religion. All governments are corporations. Proprietors of Charles River Bridge v. Proprietors of 36 U.S. 420 1837 verifiable at http://laws.finlaw.com/us/36/420.html Corporations are also of all grades, and made for varied objects. All governments are corporations, created by usage and common consent, or grants and charters which create a body politic for prescribed purposes, but whether they are private, local or general, in their objects, for the enjoyment of property, or the exercise of power, they are all governed by the same rules of law, as to the construction and the obligation of the instrument by which the incorporation is made. There is a circus of conflicting deceitful codes that act as the operating procedures of the federal corporation, the United States. Yes, the United States is a corporation. See 28 U.S.C. Section 30,020-15. The states are sub-corporations of the federal United States, the aforementioned corporation. See 1934, State Compact Act, Buck Act, 4 U.S.C. Section 101. From the earliest of times the law has enforced rights and exacted liberties by utilizing a corporate concept, by recognizing, that is, juristic persons other than human beings. The theories by which this mode of legal operation has developed, has been justified, qualified, and defined are the subject matter of a very sizable library. The historic roots of a particular society, economic pressures, philosophic notions, all have had their share in the law's response to the ways of men in carrying on their affairs through what is now the familiar device of the corporation. Law has also responded to religious needs in recognizing juristic persons other than human beings. U.S. v. Scoffany Corporation of America, 333 U.S. 795 1948 The government may carry on its operations through conventional executive agencies or through corporate forms especially created for defined ends. Federal Crop Insurance Corp. v. Merrill, 332 U.S. 380-388 1947. There is a war going on and the battle is for your mind. They are getting to your mind by going through changing your name. In Merriam-Webster, p.g. 1534, under international law of warfare, all parties to a cause must appear by nom de guerre, because an alien enemy cannot maintain an action during the war in his own name. Using this nom de guerre, you are in conflict, battle in the current, secret, commercial war. As per article by Chuck Morse, is the national emergency of FDR still in place? You will find that this was a classic example of sleight of hand. In fact, Congress exempted all laws, based on the emergency of 1933 that were already in place. Rather than being based on the authority of the President under a national emergency, these federal laws have now been codified as a permanent part of the U.S. Federal Code. Included among the codified laws would be Section 5(b) of the Trading with the Enemy Act, which classifies the American citizen as an enemy of the government. Therefore, although the national emergency technically ended on September 14, 1976, when the 93rd Congress passed H.R. 3884, the National Emergencies Termination Act 50 U.S.C. 1601, Public Law 94-412, because the last paragraph said that it didn't apply to any authorities under the Act of October 6, 1917, as amended, the classification of an American citizen still stands as enemy of the government. Now, allow me to shock your conscience a little. Not 1 in 1,000 Americans can tell me where the United States is located. No, you can't. The UCC, Uniform Commercial Code, the rule book for all transactions, is owned by UNIDROIT located in Rome, Italy, close to the Holy See, and the U.S. government pays UNIDROIT $260,000 per year for the use of their copyrighted material. Every piece of legalese that moves in, by, or through the United States is conjunction with UCC. Now, let's discover the location of the United States, UCC. Section 9-307 H Location of United States. The United States is located in the District of Columbia, and, b. A U.S. citizen, upon leaving the District of Columbia becomes involved in interstate commerce, as a resident does not have the common law right to travel, of a citizen of one of the several states. Hendrick v. Maryland S.C. Reporters Road 610-625. 1914, and, c. It is clear that a U.S. citizen becomes a resident when outside the District of Columbia, and, d. A citizen of one of the several states is not the same as a U.S. citizen. See also Internal Revenue Code Section 7701-39, which reads, A. IRC. Section 7701-39, if any citizen or resident of the United States does not reside in and is not found in any United States judicial district, such citizen or resident shall be treated as residing in the District of Columbia for purposes of any provisions of this title to a jurisdiction of courts, or b. enforcement of summons, b. Also see Internal Revenue Code Section 7408 C and Art. 1 Section 8, Clause 17 Constitution for the United States of America as defined and reinstated in National Mutual Insurance Company of the District of Columbia v. Tidewater Transfer Company, 337 U.S. 582, 93 L. ed. 1556-1948, c. Which further states that citizens of the District of Columbia are not embraced by the judicial power under Article 3 of the Constitution for the United States of America. The same statement is held in Hepburn v. Dundas v. Ellisey, 2 Cranch, U.S. 445, 2 L. ed. 332. In 1804, the Supreme Court, through Chief Justice Marshall, held that a citizen of the District of Columbia was not a citizen of a state, and d. In National Mutual Insurance Company of the District of Columbia v. Tidewater Transfer Company, Supra, we therefore decline to overrule the opinion of Chief Justice Marshall. We hold that the District of Columbia is not a state within Article 3 of the Constitution. In other words, cases between citizens of the district and those of the states were not included of the catalog of controversies over which the Congress could give jurisdiction to the federal courts by virtue of Article 3. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia and through their plenary power nationally covers those citizens even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states and union. We have just learned that a citizen of a state, any state, is not the same as a U.S. citizen. Let's discover the primary differences. The privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. Maxwell v. Dow, 176 U.S. 581, 597, 1899. Warning: chew the next one up real good before you attempt to swallow it. The right of trial by jury in civil cases, guaranteed by the 7th Amendment, Walker v. Sauvanet, 92 U.S. 90, 23 L. ed. 678, and the right to bear arms, guaranteed by the 2D Amendment, Presser v. Illinois, 116 U.S. 252, 29 L. ed. 615, 6 Sup. Court. Rep. 580, have been distinctly held not to be privileges and immunities of citizens of the United States. Twining v. New Jersey, 211 U.S. 78, 98, 1908. All offices attached to the seat of government shall be exercised in the District of Columbia, and not elsewhere, except as otherwise expressly provided by law. 4 U.S.C. Section 72. So, somebody has stepped way over the line, but how did they do it? You gave them a license to do it. Remember, under international law of warfare, all parties to a cause must appear by nom de guerre, because an alien enemy cannot maintain an action during the war in his own name. Merriam-Webster, p.g. 1534. And, The Oxford English Dictionary, 2nd, ed., Clarendon Press, 1989. It is by international doctrine that the use of nom de guerre would indicate a state of war. It is with the enforcement of obedience military jurisdiction by vi et armis force of arms that we can know the government, public law, public servants are waging war against the private citizen and the people. If you're writing tickets, fines, fees, receipts, etc., you're waging economic war on your mother, father, and kindred. According to Digest of International Law, Volume 10, and pages 95 to 127, the Departments of State, Justice, Commerce, and the Treasury, in disregard to the administrative orders of the President, conduct an alien enemy program whose sole purpose is to unconstitutionally seize the properties of all private citizens, militarily, with the aid of such maritime hypothecations as bottomry bonds, etc. Volume 20, Corpus Juris Sec. Section 1785, the United States government is a foreign corporation with respect to a state NY Re. Merriam 36 NE 505141 S. Court 1973, 41 L. ed.287. Now, do you recall that I stated above that you gave them a license by way of your name? Bouvier's Law Dictionary, 8th ed., pg. 2287. The omission of the Christian name by either plaintiff or defendant in a legal process prevents the court from acquiring jurisdiction. Your Christian name is not in all uppercase letters. And, to be a little more explicit, a Delaware corporation demands that a corporation has a last name. Figure that one out, especially when your family name is not part of your Christian appellation. Enter, the Clearfield Doctrine as the use of private corporate commercial paper, debt currency or securities is concerned, removes the sovereignty status of the government of we the people and reduces it to an entity rather than a government in the area of finance and commerce as a corporation or person. Governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen. This entity cannot compel performance upon its corporate statute or rules unless it, like any other corporation or person, is the holder in due course of some contract or commercial agreement between it and the one upon whom the payment and performance are made and are willing to produce said documents and place the same evidence before trying to enforce its demands called statutes. For purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. Clearfield Trust Co. v. United States 318 U.S. 363-371. When governments enter the world of commerce, they are subject to the same burdens as any private firm or corporation. U.S. v. Burr, 309 U.S. 242 c. 22 U.S. ca. 286 e. Bank of U.S. vs. Planters Bank of Georgia, 6L, ed. 9 Wheat 244, 22 USCA 286 et seq. CRS. 1160-103 Note, under the Clearfield Doctrine, the courts are no longer government entities in that they are demanding private monies and must have a contract with you to compel performance. They are no more special as a normal business than your local Jack in the Box. Does the court demand payment in a certain species? U.S. dollar. Did the court make payment on the record, or by way of agreement, of any entry fees, etc.? If 1 USD is given, or demanded, species HJR 192 is overridden and all instruments have become bogus financial instruments involving private creditors and all enjoined in the fraud may be prosecuted under a variety of statutes. Conspiracy 18 USC. Sec 371, mail fraud 18 USC. Sec 1341, uttering a false security 18 USC. Sec 472, bank fraud 18 USC. Sec 1344, and possessing and uttering a counterfeit security 18 USC. Sec 513. C. United States v. Uhlmann, 187 F3D 816 8th CIR. 1999, United States v. Hanslichek, 187 F3D 1228 1230 10th CIR. 1999, United States v. Wells, 163 F3D 889 4th CIR. 1998, United States v. Stockheimer, 157 F3D 1082 7th CIR. 1998. Dictionary of Law 1893 Corporation. A creature of the Crown, created by letters patent. An artificial being, indivisible, intangible, and existing only in contemplation of law. 1 Blackstone, 295. The United States may be deemed a corporation. United States v. Hillegas, 3 Wash. 73 1811, so may a state, 1 Ab. U.S. 22 and 35 Gaw. 315, and so, a county. United States under Title 28, Section 3002 15 a. United States means a federal corporation. No license of jurisdiction as per the Supreme Court in Murdoch v. Pennsylvania 319 U.S. 105, a state may not, through a license tax, impose a charge for the enjoyment of a right granted by the federal Constitution. Have you questioned, what if I have no nexus with the state in form of license granted? As per, it is impossible to prove jurisdiction exists absent a substantial nexus with the state, such as voluntary subscription to license. All jurisdictional facts supporting claim that supposed jurisdiction exists must appear on the record of the court. Pipeline v. Marathon. 102 South Court. 3858 quoting Crowell v. Benson 883 U.S. 22. And, without a license, you're not a licensee, as per, where a person is not at the time a licensee, neither the agency, nor any official has any jurisdiction of said person to consider or make any order. One ground as to want of jurisdiction was, accused was not a licensee and it was not claimed that he was. 0 NEI 1 v. Department Professor and Vocations 7 CA 2D 398, Eisman v. Daugherty 6 CA 783 and, what if you're not employed for compensation as a licensee for the act so accused, as per, agency, or party sitting for the agency, which would be the magistrate of a municipal court, has no authority to enforce as to any licensee unless he is acting for compensation. Such an act is highly penal in nature, and should not be construed to include anything which is not embraced within its terms. Where there is no charge within a complaint that the accused was employed for compensation to do the act complained of, or that the act constituted part of a contract. Shomig v. Kaiser, 189 Cal 596. More about non-granted jurisdiction as that of a licensee, as per, an action by Department of Motor Vehicles, whether directly or through a court sitting administratively as the hearing officer, must be clearly defined in the statute before it has subject matter jurisdiction. Without such jurisdiction of the licensee, all acts of the agency, by its employees, agents, hearing officers, are null and void. Doolin v. Carr, 125 U.S. 618, City v. Pearson, 181 Cal. 640. And, failure to reveal material facts as grounds for estoppel. Failure to reveal the material facts of a license or any agreement as immediate grounds for estoppel. Low Bu v. Porazzo, 48 Cal. App. 2D 82, 119, p. 2D 346, 348. And, who is required to pay for use of public highways, as per, the taxes placed upon those obtaining compensation for the use of the public highways. In Ray Bush, 6 Cal. 2D 43 Crim. No. 3945. In Bank. April 1, 1936. In the matter of the application of C. E. Bush for a writ of habeas corpus. Let's take this a couple steps further, as per, 18 U.S.C. 31, 6 Motor Vehicle. The term motor vehicle means every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways in the transportation of passengers and property, or cargo. And, as per, 18 U.S.C. 31, 10 used for commercial purposes. The term used for commercial purposes means the carriage of persons or property for any fare, fee, rate, charge, or other consideration, or directly or indirectly in connection with any business, or other undertaking intended for profit. Miscellaneous points. Point 1. The Fourth Amendment forbids stopping a vehicle even for limited purposes of questioning its occupants unless the police officer has a founded suspicion of criminal conduct. U.S. v. Ramirez and Sandoval, 872 F2d. 1392. Point 2. An action by Department of Motor Vehicles, whether directly or through a court sitting administratively as the hearing officer, must be clearly defined in the statute before it has subject matter jurisdiction. Without such jurisdiction of the licensee, all acts of the agency, by its employees, agents, hearing officers, are null and void. Doolin v. Carr, 125 U.S. 618, City v. Pearson, 181 Cal. 640. Point 3. Agency, or party sitting for the agency, which would be the magistrate of a municipal court, has no authority to enforce as to any licensee unless he licensee is acting for compensation. Such an act is highly penal in nature, and should not be construed to include anything which is not embraced within its terms. Where there is no charge within a complaint that the accused was employed for compensation to do the act complained of, or that the act constituted part of a contract. Shomig v. Kaiser, 189 Cal 596. Point 4. The high courts, through their citations of authority, have frequently declared, that, where any state proceeds against a private individual in a judicial forum, it is well settled that the state, county, municipality, etc., waives any immunity to counters, cross-claims and complaints, by direct or collateral means regarding the matters involved. Luckenbach v. The Thekla, 295 F 1020, 226 Us 328, Leiters v. Lund, 32 F 2d 308. Point 5. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. See Owen v. City, 445 U.S. 662, both Key v. Terry, 713 F2d 1404, but merely act as an extension as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. Thompson v. Smith, 154 SE 579, 583, Keller v. P.E., 261 U.S. 428, FRC v. G.E., 281, U.S. 464. Point 6. It is factual that any magistrate sitting in ministerial capacity has no ability to receive grants of judicial power from the legislature. As per, ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Burns v. Supp. Court, SF, 140 Cal. 1.7. And, as per the Supreme Court in Murdoch v. Pennsylvania 319 U.S. 105, a state may not, through a license tax, impose a charge for the enjoyment of a right granted by the federal Constitution. Biblical and logical reasons for not submitting to foreign tax. Note, a person is licensed taxed, not the real living man. A person is a legal entity, not a living man. The office of person is a privilege created by a larger legal entity named United States. A United States U.S. citizen is a person. This office of person is a license from a larger licensed corporation. Homo vocabulum est natura, persona juris civilis, man is a term of nature, person of civil law. Private law is a license, and not a contract, for the receiver of the privilege has no action enforceable against the giver of the privilege. A dispensation or license properly passeth no interest, nor alters or transfers property in anything, but only makes an action lawful which without it had been unlawful. A license is a mere privilege without enforceable rights, which distinguishes it from an easement giving definite property rights enforceable against the entire world. A license is not a contract between the state and the licensee, but is a mere personal permit. Neither is it property or a property right. Nor does it create a vested right. A sovereign the lawgiver is exempt from suit, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. Car on payet bien recovoir loi d'autrui, mais il est impossible par nature de se donner loi. Nemo suo statuto ligature necessitative. So, whatever is established by the Commander-in-Chief or Congress, is in derogation of the Christian common law, and 1. Is a privilege protected by the military power of the Union, and 2. May be taxed constitutionally as an excise for revenue purposes, derogation. The partial abrogation of a law. To derogate from a law is to enact something which impairs its utility and force, to abrogate a law is to abolish it entirely. All statutes are to be construed with reference to the provisions of the common law, and provisions in 320. Derogation of the common law are held strictly. UCC 1-103.6. Not a slave or ward of the court. Who's your daddy? Beware, all assumed or presumed authority of any governmental, quasi-governmental, International Monetary Fund, Internal Revenue Service, or any other regulatory or taxing agency functions under the doctrine of partus sequitur ventrum, meaning that the offspring is the property of the owner of the mother. Reference is made to the case of Alberti v. United States brought in 1896, approximately 40 years after the Emancipation Proclamation is proof positive that, unless proven otherwise, the federal government will declare jurisdiction based upon ownership, this long after involuntary servitude being proclaimed illegal. The case of Alberti v. United States was over the murder of a half-black, half-Choctaw man by a half-black, half-Cherokee man on Cherokee territory, with the United States demanding, and getting, jurisdiction over the Cherokee tribal justice, because of ownership. In Black's Law Dictionary, we see that a marriage license is only appropriate when a couple is contemplating a marriage between people of different races, as between a white person and a Negro. Affiant specifically denies any association with the state, any state, in the state's capacity as parens patriae, or as in loco parentis, defined below. Parens patriae, lat. Literally, parent of the country, the role of the state is sovereign. See Black's Law Dictionary, 5th ed. In loco parentis, in the place of the parent, or, instead of a parent, charged factitiously with a parent's rights, duties, and responsibilities. See Black's Law Dictionary, 5th ed. This exhibition is to dispel any presumptions, assumptions that when the mother, any mother, or other informant signs the birth certificate of the child, the presumption is that she is the black slave that is still owned by the government, or that the child is a fatherless child. Of a truth, most document administrators reporting in, and for, hospitals, do not care that there is a father's name on the birth certificate, but the mother's maiden name is paramount and automatically a ward of the court, government. Therefore, without this admonition, the doctrine of partus sequitur ventrum above may apply and the owner can do with the children as the owner wishes. Concerning such owned children of the state, the law secures their parental right only so long as they shall promptly recognize and discharge their corresponding obligations. As the child owes allegiance to the government of the country of its birth, so it is entitled to the protection of that government, which is parens patriae, must consult its welfare, comfort, and interests in regulating its custody during its minority. Purinton v. Jamrock, 195 Mass. 187, 80 NE 102, 18 LRA, NS, 925. To continue the thought, as quoted in the 2000 census brochure, the object of the census, by law, is to count the defective, dependent, and delinquent classes. Virtually everyone counted in the 2000 census is now presumed to be defective, dependent, and delinquent, and thus, wards of the court, state. Does that sound like a corporate collection of incompetent persons? In the past volley of words, the point has been made that the government has become the parent father to all children, regardless of age. The natural father has been replaced with a fictional entity, a fiction. So, what is a fiction? It is a lie. The fiction is your, if you're under governmental jurisdiction, father. Now, we see our father as a liar. Okay, who's the father of lies? The Holy Writ mentions the motherless only one time, however, it mentions the fatherless 44 times. Could there be a message in this statement? We are known as human resources in governmental documents. A resource is a claim of property and when related to people constitutes slavery. Now, a few words again about U.S. citizens according to Wheeling Steel Corp. v. Fox, 298 U.S. 193, 80 L. ed. 1143, 56 S. Court. 773. Therefore, the U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. Oh, and a couple more things, you grant a license if you hire, or obtain, an attorney, as per 7 CJS, Section 2, 3, and 4. A client is one who applies to a lawyer or counselor for advice or direction in a question of law, or commits his cause to his management in prosecuting a claim or defending against a suit in a court of justice. One who retains the attorney, is responsible to him for his fees, and to whom the attorney is responsible for the management of the suit. One who communicates facts to an attorney expecting professional advice. Clients are also called wards of the court in regard to their relationship with their attorneys. Attorney with an obligation to the courts and to the public no less significant than his obligation to his clients. Thus, an attorney occupies a dual position which imposes dual obligations. His first duty is to the courts and the public, not to the client, and whenever the duties to the client conflict with those he owes as an officer of the court in the administration of justice, the former must yield to the latter. Also, wards of the court are infants and persons of unsound mind. Davis's Committee v. Loney, 290 Kentucky. 644, 162 SW2D 189, 190. Their rights must be guarded jealously. Montgomery v. Erie R. Co., CCANJ, 97 F2D 289, 292, and that if men, through fear, fraud or mistake, should in terms renounce or give up any natural right, the eternal law of reason and the grand end of society would absolutely vacate such renunciation. The right to freedom being the gift of Almighty God, it is not in the power of man to alienate this gift and voluntarily become a slave. Samuel Adams, our great president. Now, remember, when some fat orator with a size 56 waist starts hammering on Romans chapter 13, obey those that have rule over you, exactly who or what has rule over you. Our Creator has rule over His creation. You have rule over what you create. If the state created you, they have rule over you. So, next time you hear, render unto Caesar that which is Caesar's, remind that fat $1 that Caesar is dead. Thank God for that. There is much information you must have in order to conduct and plan your service to God and country. For example, you must know who your adversaries are and what they plan and plot in order to control, enslave and destroy you. So, I'll end this little oration with a particular statement. Maybe you know who, or what, the Babylonian harlot is, and maybe you don't. Therefore, I will draw you a picture. Every jack-booted armored code enforcer that writes those collection tickets against your license and every fiction-based collector of contraband securities based upon private Federal Reserve notes and every agent that sucks your currency from your livelihood are doing one thing, and one thing only. They are feeding the Babylonian whore, and so are you when you license yourself to them. Put that in your smoke and pipe it. You are either part of the problem or part of the solution. You know what you are. Now, do you think you can become a conscientious objector to the sin of license?